I mean, I think the people that Mr. Hillygus is involved with on the outside should be a concern to the courts.
How come?
The Second Judicial District Court, seeing the matter in session, the Honorable Barry Breslow presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. Okay, we're on the record in State of Nevada versus Roger Hillygus and Stewart Handte, case number CR 19-1535A and B. Court recognizes the prosecutor's presence, Mr. Stege, defense counsel, Mr. Silverberg, seated next to his client, Mr. Handte, and Mr. Hillygus, self-represented. Let's set the table of contents for today's hearing. The court last week set this hearing today to discuss, consider, and decide the issue of whether there would be an anonymous jury in this matter. The court asked counsel to take a look at the Menendez-Cordero case from 2019. That was appealed from a decision by one of my colleagues to the Nevada Supreme Court. The court also indicated that it would make a final decision on whether cameras would be allowed during the trial today after the hearing on the anonymous jury. Corollary to that was whether the court would allow the video of court proceedings to be pushed out by media sources on a daily basis, or rather direct that it be retained until the conclusion of the trial for considerations of things like rule of exclusion. Court also indicated that it would take up today confirming what we would do on Wednesday of this week, whether there's an anonymous jury or not. Wednesday of this week, when you come to court, the court intends to deliver copies of the jury veneer to all parties, either redacted because an anonymous jury has been ordered by the court, or unredacted for use consistent with preparation for trial. Also Wednesday of this week, exhibit marking. And so, to the extent that there is some work to be done prior to actually meeting with the court clerk, the court directs counsel and self-represented party, Mr. Hillygus, to obtain a copy of the proposed exhibit matrix, fill it out to the best of their ability on what they intend to mark, and seek to admit a trial. It's also come to the court's attention that a subpoena was served on Debbie Hillygus. She has counsel who has moved to quash the subpoena. So we need to take up the issue of whether the court is going to hear that motion, and if so, when. Don't know if parties have had a chance to see that yet. The gist of it being that, to the extent it seeks disclosures of confidences during or after the marriage to Roger Hillygus, it's protected by privilege unless Mr. Hillygus himself were to waive that. To the extent it seeks information with respect to her care of the late Susan Hillygus, argument appears to be that she does not have any relevant information that others would not be able to share. And finally, it appears to the court, the argument being it would create undue hardship to her. That's just the court's summary, having taken a quick view of it. But the court will rule on that before she's called. We have to discuss as well let's back up. This supposes we're going to trial Monday a week from today, which currently is the court's plan. Now, I'm aware Mr. Hillygus filed a series of motions late last week,
I would object. I didn't file a motion.
okay?
I filed objections and I filed a notice and a demand to dismiss the case for lack of standing and lack of subject matter and personal jurisdiction. They're not motions. It's a notice and a demand for this court that once the facts are known, and if you take time and apply the law, and if you conscientiously review all the exhibits in the document that was submitted, you will dismiss the case because you will have no choice, because this is not a criminal case. There has not been any criminal act by me. And that document, that notice is quite explanatory. And if you do your due diligence, and if you apply the law to the document, you will have no choice but to dismiss the case.
All right, in the future, Mr. Hillygus, what I'm going to do is call on people to address issues that the court is bringing up. If you want to be heard, please wait until I address my attention to you.
I just need to correct
I understand, and I
the
would give-
reason. It's not a motion.
Okay, so, thank you. So with respect to that, unless the court finds merit in the positions that have been advanced late by Mr. Hillygus, the case will go forward a week from today. Now, when I say late, it's because I'm referring to two different rules of engagement. One is the recently enacted Nevada Rules of Criminal Practice that direct that any type of dispositive motion, declaration, opposition, notice that bears on whether the case goes forward needs to be filed within 15 days of the trial date. Our local rules for second judicial are even farther out, 20 days. Well, this was apparently filed last Friday, 3 days ago. Now, does the court have discretion for good cause to shorten that? It does. Does the court intend to exercise it here? I'm still thinking about that since the court, it just came to the court's attention over the weekend. But assuming we're going to trial Monday, a week from today, then I want to make sure that the state understands it doesn't seek to call Debbie Hillygus to the stand until there's been a decision on the motion to quash. Mr. Stege, you tracking on that?
In strong disagreement, I am tracking on it though, right?
In disagreement that the court's going to rule?
Well,
Or disagreement that it has merit?
As to the merits, but of course I understand the court must rule on that and will weigh in on that. I will say, I don't seek marital privilege communications in any way. And the idea of the burden on an ordinary citizen is objectionable to the state. Merely not wanting to because of...
Well, let's not get into the merits. We're just talking procedure. Procedurally, you're not to call her as a witness until the court's ruled on her motion to quash, all right?
Very well.
Good. So the court also filed, no, let me back up because there's a few moving parts here. Mr. Hillygus, late last week, the court filed an order with respect to the request of, this is Reno, for the court to reconsider its prior ruling with respect to photographs it had taken and audio it may have captured. And the court did so after the hearing last week. The court issued a written order that confirmed what it stated on the record. And that order was filed, I believe, Friday, 3 days ago. A copy was to be mailed to you, and then for some reason it did not go out in the mail. It came to my attention this morning. I didn't want to send it out in the mail today. I gave it to Deputy Allman, who I instructed to give to you. Did you receive that from Deputy Allman, Mr. Hillygus?
I received an envelope, I didn't open it up.
All right, I think that's what it is. It's, as far as I know, it's simply the court's confirming order, allowing this is Reno to use the information it obtained at a recent hearing. So that's that. With respect to other news media requests, the directive is that once our standardized form is live on the website, to use that. It'll be forwarded to the court's attention. But until that's live, until and unless that's live, an email to the court administrator who forwards it to the department will get our immediate attention. Let's talk about things like jury voir dire. So on Monday morning, we'll talk about what time we're going to have the jury brought up. But on Monday morning, the people that have been summoned for service will be brought into court. Say 9 o'clock, 9:30, whatever time we get going. At that time, the court makes introductory comments about service, about how we proceed in Department 8, about the role of the judge and the role of the jury. The charges that have been brought against Mr. Hillygus and Mr. Handte by law are to be read to the prospective jurors by the court clerk. The court clerk then, then the jury veneer is sworn to truthfully answer questions put to them about their ability to serve fairly and impartially. The court then proceeds with voir diring this jury, asking questions that seek the truth as to their knowledge about the case, if any, their feelings about law enforcement, strongly or not strongly, whether they have been subject to a crime, accused of a crime, victim of a crime, things like that, whether they know any prospective witnesses in this case. Let me stop there. When you're here Wednesday, make sure you let the court clerk know who the potential fact witnesses will be, or any expert witnesses will be in this case, so that we can put them on a list and show them to the potential jury to see if they know any of those people, and if their knowledge of them would create a conflict on their ability to serve fairly and impartially. All right, back to the types of questions the court asks. The court will ask if they have any experience with guardianships, with nursing homes, with memory care facilities. The court will ask them if they've ever been served on a jury before. The court will find out if it's been a civil jury or a criminal justice jury. The court will ask if they've ever worked in law enforcement or have somebody close to them. The court will ask if they've ever worked for a fire department or been a firefighter or have somebody close to them who's done so. And the court will ask what I consider to be very comprehensive questions of this panel of potential jurors to elicit any answers that would go toward potential bias, ability to serve, whether they have any extreme inconvenience, unjust, undue hardship that would prevent them from serving. Now, when the court is done, and that process may involve the court excusing people for cause, when the court is done, Mr. Stege goes next. He can stand right here in the well, use the podium, and ask follow-up questions. The follow-up questions are directed to the people that have been called into the jury box or in the row in front, and he can follow up on the questions from the court. He's not to cover the same ground, but he can explore more fully some of the responses or ask questions the court overlooked that he finds bear on this potential juror's ability to serve. When he's done, Mr. Hillygus, you get to go. You're the first named defendant. You can say, Judge, I'd rather have Mr. Silverberg go next, and I'll allow that, and then you can go last. But you're the A defendant here. You have the most charges being brought against you here, and so I'll let you stand up, you get behind the podium, and ask questions, follow up on issues that bear on a potential juror's ability to serve. Make sure you have read the court's order on the scope of permissible questions. Asking the jury, the potential jury, questions about their ability to serve does not mean you can begin the art of persuasion with them. It is not meant to inspire them to investigate anything. It is not meant to begin to describe your view of things. It's merely to determine whether they can impartially sit and will find the facts presented to them, apply the law the court gives them. If anyone, any attorney or self-represented defendant, stray, I'll politely remind them of the scope of what they're allowed to ask. If they stray a second time, I will more strongly remind them, and if it happens a third time, the court will reserve its right to shut down their further questioning. So Mr. Hillygus and Mr. Silverberg discussed before Monday. If Mr. Hillygus, you'd like to go second, you have the right to do so, or you'd like to wait until after Mr. Silverberg goes. When all the questioning is done, the court thanks and excuses the jurors that we don't need, and then we proceed to peremptory challenges. 24 potential jurors will be in the box. And when we have 24 that are passed for cause or over objection, the court passes them for cause. Each side can strike 4. The state can strike 4. The defense cumulatively can strike 4. So alternating. 2 by Mr. Hillygus, 2 by Mr. Hante's side to get to 4. You can certainly collaborate, but you don't have to. Once each side uses 4, we've now gone from 24 down, take 8 away, we're down to 16. Then each side can strike 1 alternate. Takes us from 16 to 14. 12 jurors and 2 alternates that will hear this case. The 2 alternates are do not know they are alternates. We know that they're alternates, but they don't. And that's the way the case proceeds. They are not to be made aware that they are alternate jurors. When jury selection is over, the state has the opportunity to make an opening statement as to its view of what the evidence will show, followed by Mr. Hillygus. Again, he has the right to go second if he chooses, but after collaboration with Mr. Silverberg, if he'd like to go third, he can. And then the final defendant or counsel goes. After opening statements are done, the state will call its first witness. Examination will occur either from counsel table or from the podium, which the court allows to be moved, again, here in the middle of the well. Nobody is to approach to get more than 10 feet in front of the jury box, and nobody is to approach a witness or the court clerk or the court bench without asking permission. I've already directed that the state make sure that the defense has the opportunity to use the overhead projectors. And if there's any issue with the audio or video files, if there are any to be played here, that everyone has equal access. Speaking objections are not allowed by the court. I mean, you have to speak, but you can't make long statements about your view of things. Object, relevance, object, hearsay, object, redundant, object, need to approach the bench. There are times, Mr. Hillygus, when you or counsel will say, Judge, I'd like to bring something to your attention outside the presence of the jury, and you can ask for permission to walk right up here. Typically, counsel and the attorneys will say, Judge, may we approach? And if I grant that, then you come right up here, you stand right up here. I put on a little white noise, sounds like this. So the jury can't listen to what we're saying. I mute my microphone, and then quietly, but so I can make sure I hear you. You tell me what's going on, and I'll make a ruling. If it's very important, if it's something that needs further discussion, then I'll send the jury into the deliberation room, and we'll handle it here in open court. That's rare, but that does happen. So that's the order of business. So let me summarize where we are. In a moment, we're going to talk about anonymous jury. We're going to mark exhibits Wednesday. I'm still processing in the court's mind what was filed by Mr. Hillygus just recently, taking into account both its substance and also the fact that it's late. I've already brought up the fact that Debbie Hillygus is not to testify until the court has ruled on a recently filed motion to quash subpoena. I reminded everyone to read the order that was filed the other day on permissible jury voir dire. I've explained to Mr. Hillygus that inadvertently a copy of the order regarding this is Reno did not go out in the mail to him, so we've had one hand delivered to him. We've talked about marking exhibits. We've talked about identifying potential witnesses. I do note that Mr. Handte, through counsel, did identify a list of potential witnesses, so we have that. The state should do the same. Mr. Hillygus should do the same. After you look at the list from those two fellows to see if there's somebody that they've overlooked. And again, those witnesses, those potential witnesses will be put on the screen or handed out to the veneer or read so they can determine if they know any of them. The recent order the court entered last week directed the sheriff to have somebody here today to speak about issues that might bear on the anonymous jury and or cameras in trial. And also, the court order last week directed the sheriff to use best efforts to make sure that Mr. Hillygus is appropriately dressed for trial. Jury instructions should be filed by the state no later than Wednesday of this week, rereading our local rules. Although custom and practice is for the defense to submit theirs either simultaneously or about the same time, according to our local rules, they can actually serve them as late as the Friday before the Monday trial. They can even serve them in camera, although the court normally directs that they be disclosed to the state, because we have to settle them at some point. Mr. Hillygus, I would encourage you during a break here today to talk to Mr. Silverberg about jury instructions, because even though we don't have to finalize those today, we don't finalize them this week, we don't finalize them until the end of the evidence. They're a work in progress along the route. We take breaks during trial and we go through them, or after testimony. We work, we roll up our sleeves and we go over jury instructions. So before I direct the argument on the issue of anonymous jury and then possibly evidence, Mr. Stege, based on what the preliminary comments the court just made, anything to add or any questions? Then I'll ask Mr. Silverberg, then I'll ask Mr. Hillygus. Mr. Stege.
Can you just clarification on jury instructions? By the passing of the statewide district court rules, they eliminated local rules, so that practice.
Well, supersede them, right?
Superseded, right? And so that practice sort of the defense not having to provide theirs is eliminated by those rules. So I would just ask the court to state a time for both parties to exchange.
Well, custom and practice, what are other departments doing?
Well, that rule went away. That rule allowed for ambush. They don't allow for ambush anymore, so now they're requiring that they both be provided either on Wednesday or Friday.
Okay.
before trial.
Mr. Silverberg, strong feelings on that either way.
Preference would be Friday.
I'm okay with that.
All right, so Mr. Hillygus, summarizing this, Mr. Stege reminded the court that the recently enacted Nevada rules of criminal practice supersede the local rules. It's the local rules that said the defense counsel or the defendant can have their jury instructions in camera no later than the Friday before trial. But now they all have to be delivered either simultaneously or close to it. So if you have proposed jury instructions that you want to give, you want the court to give, they need to be delivered to the court or otherwise made available by the end of this week. Do you understand that?
I would enter an objection at this time. I think I've explained to you prior that there was an order that you ordered the prosecution to provide me written rules, criminal procedure, which have not been provided to me. So I would object that he is in violation of your order, that sanctions should be issued, and that I be provided with the rules that you ordered to be provided to me in a paper copy so that I could look at them while I'm locked down 23 hours a day. Violation of my due process rights for him to violate a court order and to not be sanctioned, and for me not to be provided the rules that I need to review.
Mr. Stege, would you like to respond to that?
Yeah, the court's amended rule eliminated that requirement because it was presented that you will have access by computer to a database which contains such rules, a law library, if you will.
I would object to what Mr. Stege offers. It was a court order that he provided me with the printout. It's very clear that that was to be provided, and it was not.
Are you telling the court that you do not have a copy or access to the Nevada Rules of Criminal Practice?
I'm telling you, I do not have a copy as ordered by you, a paper copy that was ordered, and I don't know if I have any other access to that. What I can tell you is the computer, the laptop is not working, the password is not functional. I put in a request to the IT person to find out how I could get that. I was denied to get the IT person to fix the password, so I haven't had access to the computer. So that's another violation because I'm being locked down 23 hours a day. I'm not being provided due process. I'm not being able to do the research that you ordered me to do. The computer and the IT people, the password would not work. I tried to get it fixed. They're denying me to give me the name of the person to provide me the information that I need to get onto the computer. I'm not being given time to use that computer. It's only 3 hours in the morning during tier time, the way the order was written. I'm not getting tier time in the afternoon, so if I don't have access in the morning or if I don't have tier time, I can't use the computer. My due process is being extremely limited in this capacity, and as we're proceeding here, I need to advise the court that I object to this hearing. I object to anything moving forward. I'm under a physician's care. I was medically neglected and criminally neglected by I was left in the sun for 2 hours. I had heat stroke, heat exhaustion. I had a medical emergency. I was rushed to the infirmary where I'm now being housed under a doctor's care. I'm being given muscle relaxers that I'm on right now. I'm having side effects. I'm on medication that I cannot properly understand everything that's happening. I'm having dizziness right now. They have been informed that there's a civil rights complaint because this is the second time that I've had criminal negligence applied to me where I was threatened and assaulted in this facility. Now there is a doctor's approval and a scheduled appointment for me to go to a hospital for therapy and for neurologic issues which are occurring, which are seizures, which are vertigo, and I'm to have therapy for that. And I'm on medication, muscle relaxers, Keppra for seizures. And this has just happened, and they're trying to cover this up. And this has been now provided to the commissioners, to the state lawmakers, to the Supreme Court and others, because this is criminal negligence, medical neglect, and it's possible homicide because I was left for 2 hours in the sun with no way to get out of the sun. They did a count where they went around with a picture of every inmate and they confirmed that I was in my cell when I was outside in the sun dying of heat stroke. And this only happened 6 days ago, and I cannot proceed, and you need to understand that this is happening to me.
Okay, hold on. Two things. First thing, Kobe, please, between you and my JA, print out a copy of the Nevada rules of criminal practice and bring them back into the courtroom, all right? Second, with respect to your medical status, I want to make sure that you are well enough to understand what we're doing in court today, that you'll be well enough to understand what we're doing in court on Wednesday, and you'll be well enough to proceed to trial. Now, are you telling me, Judge, based on my condition, the medicine I'm taking, my how I feel, that you haven't understood what we're doing so far today?
I'm telling you that I'm in solitary confinement, that I'm being isolated in the infirmary, that I'm under a doctor's care, that I'm under prescription medication, and I'm under a scheduled appointment for neurologic conditions at the hospital.
Well, one of the options available to the court is that I appoint the Washington County Public Defender to represent you for the limited purpose of advancing your position with respect to your medical condition and its impact on this matter moving forward. Because right now you don't have an attorney to move these arguments forward or explain them to the court with documentation and testimony sufficient for the court to make any definitive rulings on how this affects your ability to understand the charge and defend yourself. Right now, I'm hearing from you what's happening. But you saw my order from the other day that, absent documentation or other sufficient evidence from the court that in front of a jury or during the jury or dire process, you're not to appear in a wheelchair unless I have a good reason to allow it, a medically indicated reason, some type of documentation or some type of testimony. But let me just think on what you said for a minute. Mr. Silverberg, do you have any comments on what you just heard with respect to how it impacts your client and moving forward in this case? And I'll ask the state their view as well.
Well, I certainly don't represent Mr. Hillygus, but it concerns me when somebody comes before the court and says that they're unable to prepare for him for a number of reasons. His conditions of his confinement, and as well as, sounds like some serious medical conditions. Now, I believe there's a nurse here from the jail, but I'm not sure. I thought I saw a nurse, and maybe that's somebody that could enlighten the court. Obviously, Mr. Hillygus should know about his privacy rights in that regard, but maybe that's something the court and the council would want to inquire to see. Of course, it affects Mr. Handte. If Mr. Hillygus is not able to proceed in his defense, I think it is important for Mr. Handte that Mr. Hillygus be 100% or as close as can be, so that the entire case can be presented. So I do have a concern about that. I personally feel prepared on behalf of Mr. Handte, but a lot of that depends on Mr. Hillygus and Mr. Hillygus being ready to go forward. I haven't had discussions with him. I know he's having some medical issues. I know a little bit more about it now, just like everybody else. And it sounds to me that I would imagine his head is not foremost thinking about his defense as opposed to what appears to be some pretty serious medical issues, neurological, seizure disorder, medications. So I think that's a serious issue for Mr. Hillygus, and it does affect Mr. Handte. So in that regard, I think it's something that needs to be considered. Number two, Your Honor mentioned the witness list, and I believe witness lists need to be provided 10 days before trial. To the extent the state has not done so, I would object and move to dismiss on that basis, as they have not complied with the rules. They did disclose some experts last week, so I think it was on their radar, but between not getting the witness list this week, or 10 days before, and over the weekend getting another dump of discovery, I think 3 different dumps of discovery that'll take quite a while to get through. It's a trial tactic that concerns me. It's trial, to use the state's word, it's ambush. That's what it is. When we're a week before trial and we're getting discovery dumped on us, things that I'm reasonably sure the state had in its possession well before, but we're just getting it now, that concerns me. And it concerns me that we still don't have a witness list. Now, I know the universe of witnesses that are out there, that's quite unfair to the defense to wait until now Wednesday. Maybe we'll get the state's list of witnesses. I would get concerned about that and how it affects my ability to adequately represent the state.
Mr. Stege, would you like to be heard on any issue we've just covered? And do me a favor, slide the microphone in front of you if you're going to be seated. If you're going to stand, keep it near you.
Yes,
Let's talk about Mr. Hillygus' health concerns that he's raised. And what impact do you believe the court should view it with respect to these matters?
minimal impact, almost no impact. I would ask the court to reflect on Mr. Hillygus' long history in this case and in the guardianship cases of delay. Even in this case, he was ordered to appear and went on the run for a number of months. There are members of the sheriff's staff here, I think, who can enlighten on the question of the medical questions, and most importantly for the state, really plan by the defendant to seek to delay this matter as it approaches trial. I think we can all be enlightened by testimony from those staff. Switching to Mr. Silverberg's complaints, 174, 234 requires 5 days. It's 5 days before trial, so that rule's misquoted. I plan to file that. It's in process as.
You're talking about the witness list.
The witness list. I have to learn more about this discovery issue. Mr. Silverberg and I were in discussions last week about some other matters, so I would need to speak with him further about that. There was some pinpointing of things that he was interested in that we were able to work through last week. So.
And that, just for extent, I appreciate that from the state because that issue was resolved. The matters that were provided over the weekend in discovery had nothing to do with anything that we discussed before. I believe they were.
So this is new stuff.
Well, it's new to us. I don't think it's new to the state. I think some of it was Mr. Hillygus' recorded statements from Los Angeles to here. So I'm sure that's something that's been in the property of the state for some time now, but I think it just got, I think it was just disclosed over the weekend. 9 hours of a drive and the testimony and the statements, I'm guessing. So, you know, it just continues to put us in a very tough position, and it's frustrating.
As to that, wrong. The issue here is Mr. Handte has been through 4 or 5 lawyers here, including representing himself. His defense has been aware and has had those materials in question for quite some time. I'm not able to today pinpoint the defense's possession of any particular piece, but I know that particular piece in review has been received by both Handte and Hillygus' side since the inception. And Yar, will you ask Mr. Handte to stop speaking over counsel when
Well, I'm going to ask everybody to just keep their thoughts to themselves till the court directs a question to them.
So from the inception, from when Mr. Houston was on the case, when Mr. Gilbert was on the case, Mr. Pitaro was on the case, Mr. Handte himself on the case, all previously been provided in conformance with Chapter 174.
All right, I understand your position. Let me think more about how to handle the concerns Mr. Hillygus has raised about his medical status.
There is one other issue that you need to also realize is that I've had an ADA advocate that has tried to represent me here and has been denied because the court is supposed to, under federal law, have what's called an ADA coordinator, not the clerk. A coordinator is completely separate from the clerk. And the ADA coordinator is to coordinate with people that have ADA issues. And I've had an ADA advocate in Missouri, and I've had an ADA advocate wanting to represent me here that's been denied. So that's also another reason that this case should be postponed until I can have an ADA advocate and an ADA representative. Americans with Disabilities Act, ADA. It's federal. They put requests into the
Well,
court.
let me do this. Let me give some more thought here while we're handling issues with respect to potential anonymous jury on how the court would approach concerns that you've raised this morning about your medical status. You seem alert today. You appear to the court to have understood what I've said. You're making arguments to the court on legal positions. So I'm not going to stop this hearing and do anything with respect to appointing someone to move forward your medical condition status issues. But I may do that, but I'm not going to do it now because what I want to do is talk about whether we're going to have an anonymous jury or not. So let's, first I'm going to invite the state to inform the court of its position on whether it believes the court should consider that and should actually order that. Then I'll invite Mr. Silverberg, then I'll invite you as well. And again, anonymous jury, anonymous. I mean, there are people, they'll come here, they're from this community, they're residents of Washoe County, they have the right to serve as jurors. If they've been convicted of a felony, they've had their civil rights restored. They have to have enough understanding of and proficiency in the English language. They don't have, must not have any physical or mental health limitations on their ability to serve. And so they come in. Now, anonymous means that we do not see their names. Anonymous means we do not see their address where they live. Anonymous means we do not see their date of birth other than the year. Anonymous means we only know what zip code they are called from. With respect to their employment, that's a close call. The court will likely redact that, but ask them when they're called for service, if they're employed in what capacity, profession, or job, and the name of their employer. Then nobody can look them up. Nobody can surf them on the internet. Nobody can run criminal justice histories on them if they're inclined to. Nobody can have people that are interested in the outcome of this case do anything that interferes with their safety or impartiality. As I mentioned, I think last week, in making this determination, the court looks to things like if the particular charges against the defendant or defendants in the case involve organized crime. There's no allegation of that here. Next factor is whether either or both defendants participate in a group with the capacity to potentially harm a juror, either personally harm or harm them, financially, economically, public scrutiny, anything like that. Third factor, any past attempts of a defendant or defendants to interfere with judicial process or witnesses. Next factor, the potential length of any period of incarceration in the event of a guilty determination. Next is whether the publicity associated with these proceedings would enhance the possibility of jurors' names being made public if they were not anonymous, and possibly expose them to intimidation or harassment. So factor one, involvement with organized crime, it's a non-factor. It militates in favor of not imposing an anonymous jury here. The other factors are what we're here to talk about, factors 2 through 5. That being said, Mr. Stege, do you have any preliminary thoughts before we hear from the sheriff and anybody else that would like to be heard?
My preliminary thoughts, right, I would also sort of focus the court's attention on the term anonymous jury really means some degree of redaction of biographical data from these forms. I think the court's concerns are related to sort of the barrage that anyone involved in this case gets from email, actors, mailing things. Now, it's difficult to, and juror questionnaires do contain email information. There's also evidence already in this record of groups affiliated with the defendants seeking to locate information, addresses, so forth, file liens on people associated with the case, contacting witnesses after the fact. So those are, I think, where the court's concerns are. And so to the extent that that is a risk, and there's a real risk in, by talking about this is going to give people ideas, right? People associated or affiliated with the defendants, in particular Mr. Hillygus. So to that extent, I do support redaction of some of the information contained in the questionnaires. The email address is important, other contact information.
Phone number, last name,
perhaps first
actually
name.
first and last name.
First and last name. Particular, if someone's employment status is so particular that it would be easily identifiable through sort of a general public or public domain search, I would expect that to be on the table for redaction, really to sort of respect or protect the integrity of this process. And also, the court has addressed it in the media coverage aspect as well as in the change of venue motion. I'm aware of, in sort of my brief time here, being done in two cases, the one being this Menendez-Cordero case. Prior to that, we did it in the outlaw motorcycle gang killing at the Nugget. And so
You were the prosecutor in that case.
I was
Were you the prosecutor in
No.
the murder case?
In the latter I was, in Menendez-Cordero I was not. So certainly there are no broad comparisons to those types of violent groups. However, it's this prolonged and sustained, and really that there's evidence in the record that it's coordinated by the defendants. And so I would support an anonymous jury in this case for that reason.
Okay, Mr. Silverberg, your thoughts, please.
Thank you, Your Honor. I did have a chance to look at the case that Your Honor mentioned, the Menendez-Cordero case. Also, since we didn't have a whole lot of case law here in Nevada, I looked at the Ninth Circuit as well. It expands a little bit more, and specifically I'm looking at U.S. versus Shryock, Shryok, and that citation, Your Honor, is 342 F3rd 948. That's a 2003 opinion out of the Ninth Circuit. Kind of breaks down those five elements that Your Honor talked about. And in looking at that case and looking at the Menendez-Cordero case and related case law, it seems like one, that it's a rather extreme remedy or extreme act for a court to take. That there's a lot of concerns about the presumption of innocence and the jury wondering, oh my God, why is this happening? And there must be some real bad actors. So the courts are concerned about the inferences that are drawn by potential members of the jury panel about the defense. And they also seem to arise in the context of very violent cases. The motorcycle case, we have the case that I just spoke about, U.S. v. Shryock, where there's RICO and lots of history of violent bad actors. And none of that is present in this case. What we have here are people that are concerned about the proceedings and don't mind going public about making those concerns felt. And they're totally allowed to do that. Your Honor, just place certain restrictions, as the court is allowed to do. And I don't think it needs to go any farther than that. I think it creates, it basically creates an appealable issue that doesn't have any business in these proceedings, because these individuals are not the type of actors that we see in the cases that do lead to anonymous juries. And I think that it's going to create more issues regarding the perception of fairness of the proceedings than it is going to prevent anything from happening to a potential juror who there's no indication to think anything like that would happen. So I don't see any necessity or any real reason to veer off the normal path. And we panel the jury in the normal sense. If there ends up being a problem, just like anybody trying to contact a juror, that's going to lead to a mistrial, possibly other consequences depending on what happens. But I just don't see that as the issue in this case. And I also want to push back a little bit on the issue of lots of publicity. That really isn't a lot of publicity. There's a group of people that are very interested in this case, but I don't see that it's made the local news or national news or anything like that. I think it's a very small group of people that are following it and have a very legitimate, serious interest in it. But I don't see how that any of those folks have shown themselves to be a danger to anybody. And I think that it would be an abuse of the court's discretion to order an anonymous jury.
Thank you. Mr. Hillygus, do you have a position on this you'd like to share with the court?
An anonymous jury would be extremely prejudicial to me.
How
and
so?
to my defense.
How so?
That this is mainly a federal racketeering organized crime issue. That this case, the facts and the truth are being suppressed. Mr. Stege has all of the facts and evidence through emails and text messages that I sent from Missouri and from the Washoe County Jail that are being suppressed. So to have an anonymous jury.
Let me stop you. That's not helping your argument that the court should not have impanel an anonymous jury. That you're actually right now talking about websites that people can go to look at what you believe to be facts that support your view of things.
Well, they are facts because they have been noticed and provided to the people that are in the judgment at the 3 judges or 3 justices in Texas have made a ruling and a judgment. And it's just like we have 9 justices with the United States Supreme Court, SCOTUS. There are 3 justices in Texas that have made a judgment that all of the actors have been given notice and of the facts, and they've refused to refute the facts.
Let me ask you
All
this.
I'm saying is that if somebody wants to see the facts, that they can go to
I
the
heard you.
site and learn the
Let's
facts.
talk about things like how is it prejudicial to the defense for the court to not disclose these people's names, email, phone number, and address?
There's no injury that's going to happen to anybody. There's research that needs to be done to properly select proper jurors. To anonymously hide the people is prejudicial because there is no way to know who they are, who their neighbors are, who their associates are, and this is a stacking of a jury anonymously, and it's extremely prejudicial to the defense to have people that live in this community to wonder why they have to be anonymous on a case that there is no facts. The facts are all being withheld in this case because the facts are, this is not a criminal case. And my document that I filed that you're going to review and give some deference to, you will end up dismissing the case and save the taxpayers a lot of money because this case has already cost the taxpayers probably millions of dollars of unnecessary money because of unclean hands and crimes that have happened by the Reno police, the LA County, where right now there's a FOIA, Freedom of Information Act, that's being redacted 99%, 220 pages. That's under appeal. So the federal court and the Department of Justice is looking into this. There are facts in Missouri that are, I've sent numerous text messages and emails, and the prosecution has provided some of those, but they've not provided all of those, and I've asked that all of those be provided to me so that I can use those as evidence. So the facts are out there. This is not a criminal case. I did not kidnap my mother.
Okay,
This
I need
This
to.
jury nullification.
Okay, but I want to keep the train on the track here. The track is, you believe it would be unfairly prejudicial to you, to the defense, to have an anonymous jury. Do I have that right?
It's absolutely should not be entertained at all.
Before I make a decision, I want to hear from the sheriff. Is there somebody here from the Washington County Sheriff's Office who can give some testimony about any activities by Mr. Hillygus that in any way would bear on this issue? Is there somebody here? All right, would you please come forward, tell us who you are, and I'm going to have you take the oath of witness. Good morning. Please raise your hand and be sworn.
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, and help you God? I do.
Thank you. Please have a seat. Deputy, make sure the microphone is green. You can see we're a bit old school there. We have blue books there. You can adjust the microphone. You can grab it. And the key for that is get pretty close, speak up, and when you're ready, please tell us your name and how you spell your name.
Deborah Marino, Moreno.
Thank you. And what is your position, please, with the Washington County Sheriff's Office?
I work at the Washington County Sheriff's Department. I work in the inmate management unit.
Okay, and how long have you had that job, please?
I've been with the Sheriff's Department for 23 years, and I've been in the inmate management unit for almost 20.
And can you describe for us, please, what your job duties and responsibilities are?
Job duties in the inmate management is we basically handle all the inmates that are in custody. We do their housing, their classification levels, any security levels, disciplinary stuff. We also monitor phones, mail, emails, visiting, assist agencies as needed, as well as our own.
Okay, have you had any direct or indirect interaction with Mr. Hillygus while he's been incarcerated?
Yes, I have.
All right, and has it been moderate, extensive, modest, minor? How much interaction have you had?
I see Mr. Hillygus, when he first came into custody, I saw him twice a month, sometimes more than that, regarding ADA stuff. Recently, in the past 2 times I've gone to see Mr. Hillygus, he has refused to talk to us or talk to me about ADA stuff. Usually in the past, when he has brought ADA stuff to my attention, I have gone to medical and talked to medical, but then Mr. Hillygus is not following what medical is telling him to do.
You mean medical care or treatment?
Yeah, medical care and treatment.
Right. Let's talk about your knowledge or information that's come to you, please, on issues with respect to Mr. Hillygus's interaction with the outside world and those people's ability to potentially harass or attempt to intimidate potential jurors in this case. Do you have any information that would suggest he's doing anything like that, or that people that are in support of him are should be of concern to the court?
I mean, I think the people that Mr. Hillygus is involved with on the outside should be a concern to the courts.
How come?
Mr. Matt Scarlartos sends in emails quite often to several hundreds of people. Mr. Hillygus talks to Matt on a daily basis, and Mr. Hillygus will hear something going on in the jail, and then he elaborates it to be something totally that's not going on in the jail, or puts his own thought process into it, and then he talks to Matt, and then Matt puts his spin on it, and then they're sending in emails about things that are not happening or not going on. I do know that this anonymous jury has been a conversation that Mr. Hillygus has had with Matt, as well as Donna and other people that he talks to on the outside.
Who's Donna?
Donna is a female that Mr. Hillygus calls and talks to.
Okay, and do you have any concern that she might attempt to influence people in a way that harasses or attempts to intimidate the potential jury pool?
Yes, because I know it's been a conversation of theirs. From what the conversation suggests, they are trying to figure out, like they want to be able to find out the jurors' addresses, phone numbers, emails, where they work, their neighbors, and just regarding the emails that have come out to like the sheriff's department, the DA's office, the judges.
What are those emails like?
I would object to everything that this witness is testifying to, as she's arguing facts not placed into evidence. It's all hearsay, and everything that she has to say is her own opinion, and she's not talked to any of these people, so I would object to this witness, and everything she has to say is there's no facts, there's no emails, I've not been provided any of these emails that she's talking about. This is all her own contrived information through her own mind. This is prejudicial to me, and I would object.
Right, your objection is noted. Please continue.
So the emails Mr. Hillygus is having with these people on the outside, there was, they refer to law enforcement, the DA's office, the judges, as part of the Holocaust, Nazis, sex trafficking. There was a conversation with Mr. Hillygus and Matt and Donna, and I even want to say Kathleen, regarding trying to find out like where these people, these DAs and judges, where they eat stuff, their neighbors, so they can go.
Excuse me 1 second.
I would object again to First Amendment right. I have a right to speak to people on the phone, and I'm not doing anything illegal. I'm talking about my case, I'm talking about my strategy for my defense, and everything that she's saying is fabricated, and there is nothing in writing to support and substantiate what she's talking about.
So here, let me tell you this. Your objection is noted. Sorry, let me say this. Your objection is noted for the record. I will give you a chance under oath, or you swear or affirm to truthfully respond. You can tell me your side of this. You don't have to do it in the form of an objection. Let me hear what she has to say, then I'll hear from you. Go ahead, ma'am.
Your Honor, if I may.
Go ahead.
I would also propose an objection in that we're talking about emails and documents that we don't really have before us. It should be-
Well, there have been numerous emails that have been directed to the court that have been not reviewed or not considered, I should say, but they've been filed in this. There are close to half a dozen at least by now.
I understand that, but we don't know that those are the emails that this witness is.
Well, that's why I'm asking her to describe what the emails are.
And I understand that having her, it's not the best evidence, Your Honor, and that's, therein lies the problem, is we don't have the ability to do effective cross-examination when we don't have these emails that this witness is talking about. So it's real, again, it just kind of puts us with one hand tied behind our back trying to argue this. And then one more thing, I know Your Honor asked for preliminary statements before, but
Sure.
to the extent everything we're hearing here relates to Mr. Hillygus, it has nothing to do with Mr. Handte. No, so if Your Honor is inclined to grant an anonymous jury, then Your Honor should fight it, because nothing that Mr. Handte has done in this matter would warrant any such action.
You know, it came to the court's attention that Mr. Handte apparently sent another threatening email to the Washoe County Commission just a couple days ago. The court as well is aware of several other concerns the court has raised with Mr. Handte from time to time about the manner in which he's expressing his views on things. They may not be the same concerns that the court has with Mr. Hillygus, but certainly they are of concern to the court. But we'll talk a little bit more about that if we need to shortly.
Thank you.
But your objection is noted that the witness is talking about emails that we don't have them up on the overhead, and so we're not exactly sure which one she's talking about. Okay?
Thank you.
Do you remember the line of questioning you were responding to, Ms. Reno?
Yes, you were asking me kind of like the content of the email.
Yes.
So there is an email that went out and conversations as well between Mr. Hillygus and Matt about a Jody coming up here to Reno and getting together with Mr. Handte and going around to places that the judges, DAs frequent, their place of business or where they go to eat or their neighbors, and telling the neighbors that the DA, the judges are sex offenders, are corrupt, wasting taxpayers' money, sex trafficking, people down at the CARES campus.
Okay. Have you seen these emails yourself?
Yes, I have.
About how many total that are, speak to any of the issues you testified to?
I would say there's probably at least 8 emails that have come in that relate to those issues.
Mr. Stege, do you have any questions for this witness?
And have you seen any coordination or sort of media angle to this?
Clear the court's a little bit under the weather, did test negative for COVID, and we're wiping down all the areas that people touch on a regular basis, witness station, desks, jury box, and I'm gonna mask up here, so I don't want anyone to be concerned that I'm gonna make them sick. We're also keeping the window open here, and during recesses, we open it wide to get some fresh air. Please continue, Mr. Stege.
With it, do you see coordination from Hillygus to the Scarlatos and this other woman to push out these emails?
Yes, he's part of it. They have discussions about it, and they'll tell him, yeah, we're getting ready to send this email out, or get this information out. So yes, he's very well aware of it.
Including to legislators, county commission, basically as many email addresses as they can find.
Yes,
And do you see coordination in what you're monitoring with Mr. Handte?
yes, there is some of that as well.
And
How so?
Because the emails that Mr. Handte sends into the jail has all their names attached to it as well. And there's been conversation that Matt has had with Mr. Hillygus that, that things are being sent out on his behalf.
Please continue.
and that those, what about sort of like something big coming or a plan for disruption of this trial?
Yes, there was some that was supposed to be sent to you last week, Judge Breslow. I don't know if you received it or not. I think it was some type of an email. And then just last night, Mr. Hillygus had talked to Catherine, and she was telling him to cite the Texas site that he just cited a few minutes ago in front of the jurors, so that the jurors would be curious as to know what Mr. Hillygus was referring to, and they would look that up. And she basically told Mr. Hillygus to ignore what you had to say.
And you just heard in the objection, Mr. Hillygus mentioned that as a strategy, he would like to engage in other types of juror misconduct nullification.
Yes,
And is that consistent with what you have been monitoring with Roger Hillygus?
yes, it is.
And broadly speaking, is it fair to describe that Mr. Hillygus appears not to believe in the rule of law or the authority of this court?
Objection, Your Honor, it's fine on that, as would be the lack of relevance as well.
It's incredibly relevant.
That's a little bit of argument as opposed to a fact question. I'll sustain the objection. You can ask it another way.
In your monitoring of the communications of Mr. Hillygus, does he believe in the authority of this court?
No, he does not.
Judge, do you want to speak of the medical portion of this?
Well, only if Mr. Hillygus, if we go up there, we seal this. If we're talking about his medical care and condition, that's sensitive stuff. So he can either waive that, let us go forward, but I'm gonna shut down any reporting on this and direct people not essential to this hearing to step outside.
Well, and as I sort of see it, the court sort of put the burden on the defendant. If he wants to appear in a wheelchair, he must do it himself, or he must bear that burden of persuasion for the court.
True.
So,
Or are you thinking how to proceed, or you want me to make a decision here?
I think I'll leave that medical issue
Okay,
for
to him.
to decide at the moment. I wonder if you can just say in general, have there been other efforts or other conversations by Mr. Hillygus to delay or disrupt these proceedings?
Yes, last week he was supposed to go to court, and Matt told him on the phone it wasn't a good thing for him to go to court. Matt's specific words were to lay low for the court on last Wednesday and to lay low for court on Monday. And he even referred to Mr. Hillygus as trying to go to the, in quotes, the H, which was referring to the hospital.
Right, to sort of try to go to the hospital as a tactic to avoid punishment.
Yes.
Thank you, Judge.
Mr. Silverberg, you made a question, Ms. Marino.
Thank you. These emails that you're referring to, what do you do with those when you read them?
Actually, they come in, were sent into our, at that time, our Captain Caldwell, and so they were forwarded to our office. They get printed up and put into Mr. Hilligus's file.
And is that where they stay?
Yes.
They're not provided to the state?
Some of the emails I have forwarded to Investigator McVickers.
So you had emails that you had not provided though, is that correct? That are relevant to this hearing?
Provided to
To the state, to the court, to Mr. Hillygus, to me?
well, there's like a list of like 100 people on there, and I'm not sure whether the state, the DA's office gets all the emails, because there's just 100 different people that are listed on those emails, and I don't know if they all work for Judge Breslow or they work for whomever. They're just forwarded to our department so that we can put those in his file.
So you have a file on Mr. Hillygus?
We have a file on every inmate.
Okay. In Mr. Hillygus' file, there's all kind of emails. What else is in his file?
Behavioral stuff, if there's been any behavioral issues, his classification, questionnaires, things to that sort.
And you've read these emails?
Yes.
You've read every email?
Yes.
So my question is, in those emails, has there been any threat to potential land of threat of juror?
Not a juror per se, no.
And there's nothing wrong with this, with any inmate communicating, certainly pursuing, with whatever limitations the court may place, but there's nothing improper about him communicating with Mr. Scarlatos or any other number of people, correct?
No, there's not.
Thank you.
Mr. Hillygus, you can ask some questions of Ms. Marino based on the testimony she's given. Statements about the strength of the case against you, the ultimate determination, the motivation of those prosecuting you, things like that. We're not here to talk about that. We're here to ask this Mrs. Marino, who you apparently dealt with, if she has any factual basis relevant to the issue of an anonymous jury.
Can you explain to the court your background and training in the legal profession? Are you a lawyer? Can you explain about your legal training?
No, I'm not a lawyer.
Are you medically trained? What's your background? Are you a doctor? Do you have any licenses for medical care?
No, I'm not a doctor.
So do I have a First Amendment right? Do you believe that I have a First Amendment right to speak to people on the phone about this government, this court, this way that this is being handled? Is that illegal?
No.
Is anything that you reviewed illegal that I'm doing?
No.
If it was, would I be charged with criminal crimes for what I'm talking to people on the phone about?
Well, that's make an argument to me in the form of a question, so you don't have to answer that question. But
You claim that you have a,
But hold on. Your point is, to me, Judge, I haven't been charged with any crimes based on my communications with outside people. that the point you're trying to establish?
That is the point I'm trying to.
All right,
establish.
understood. What else can we ask Mrs. Marino about?
So you have a file on me of all my emails, and you're providing those to the prosecution, is that correct?
I'm not providing all the emails now.
Are you providing emails of mine to the prosecution?
Yes, I have provided a few emails, but they also have, the investigators also have access to the emails.
How many of those have you provided to me?
Hold on.
Objection relevant.
Yeah, that question doesn't make sense. So here's what I heard her say. And tell me if I have that right or wrong, Ms. Marino. About 6 to 8, you have forwarded on to the investigator perhaps, or?
Yes, because I'm referencing it in an email, so I just want him to have that. But the investigators with the DA's office, they already have access to the system, so I'm not providing them with anything that they can't access themselves. It's just if I'm referencing it in an email, I want it to all make sense.
All right, so really the question is why those 6 or 8, not the other 100? Are those, did you find something unusual or concerning about any of those 6 to 8?
A couple of emails just what Mr. Hillygus was going to be attempting to try to do with not showing up to court. The email with Jody coming up here to hook up with or get together with Mr. Handte to go around and find where these DAs and judges hang out to harass them, to tell the neighbors things about them.
Okay. Any other questions, Mr. Hillygus?
So I do have some more questions.
Go ahead.
How many total emails are there in the file?
I don't know how many total email, you mean altogether emails? No, I don't know how many total
Altogether.
email.
Hold on. So is it fair to say there are hundreds? Mr. Hillygus' file?
Not every email gets printed up. It's on a system that can be printed up. I wouldn't say there's hundreds of emails in his file, no.
Okay.
Can you tell me if there's been at least 200 sent just to one person?
You do send out a lot of emails. To what extent, how many emails have gone out? No, I can't say there's been 200 emails to one person.
All right.
Are we talking about emails that I'm sending out, or are these emails that people are sending in to me?
They're both.
Okay.
The only way you would be able to know how many exact emails you sent out and how many emails came in, you'd have to hand count every single email to figure that out.
Is that something that you could do, like today?
Well, I'm not having her do that, but
But we're talking about hundreds, if not thousands of emails between people sending them to me and me sending them out. And she's talking about 6.
she said 6 to 8, but here's the
So
thing.
what's amazing to me is how many people are spending so many hours reviewing my emails, and all I'm trying to do is defend myself, and I'm not putting out anything illegal. In fact, I'm putting out a lot of facts that that's not being talked about. So everything that they're talking about is prejudicial to me because I'm not doing anything illegal. I have a First Amendment right to freedom of speech to talk about what's happening with the prosecution
Mr. Hillygus,
and this court.
I understand where you're coming from, but even one email that potentially gives the court concern that jurors could be harassed or intimidated could be enough to tip the scales here. That's why we're having this hearing. So let me start over. Final question, if any, from the prosecutor, and final question, if any, from Mr. Silverberg, based on anything they've heard, and then final question from Mr. Hillygus. Mr. Stege, anything else from Mr. Marino?
Thank you, no.
All right, Mr.
I have
Silverberg.
one other question.
Go right ahead.
How is it that you requested your appearance?
Well, I ordered that omnibus order I sent out.
The judge.
And relevant.
I understand, I wanted, how is it communicated to you?
Objection relevant.
Hold on a second. Is the objection she shouldn't have to answer who told her to be here?
Well, does it matter to the court who told her to be here today?
It does not. So the objection is sustained. All right. Anything else, Mr. Hillygus?
Actually, it does, if I may.
Go ahead.
Record. Thank
Sure.
you. I think it is relevant in this matter to know who it is. We've got a file on Mr. Hillygus. that he hasn't seen, and now we have Ms. Romero here. Thank you for your appearance. Just want to know how that was communicated to her, and how is it that she's here?
Say, the objection, the court's decision stands. Thank you. Mr. Hillygus, any final questions, fact-based questions here that can inform the court's decision?
I would object to all of her testimony, and I request that it be stricken from this record because she's arguing facts that have not been placed in evidence. I have not seen or been provided with a copy of what she's talking about, and I do request that I be provided with all the paper copies of every email I have sent and has been sent in to me so that I can use those as evidence in this forthcoming trial.
Okay, thank you. Ms. Marino, you may step down. Thank you for your testimony. I'll give you 1 minute to summarize your position now that we've heard from the witness. Then I'm going to take a short break and come back and decide whether there will be an anonymous jury or not. Mr. Stege.
The court previously offered Mr. Hillygus the opportunity to.
You're right. I beg your pardon. Thank you for reminding me. So, Mr. Hillygus, there are points you want to establish here. If you want to inform the court on these issues we talked about, I've already told you there's no evidence that either of you were involved in organized crime. That's not a concern of the court for anonymous jury. The issues that we're really here to discuss are 2 through 5, the non-exhaustive list of factors courts look at in deciding anonymous jury. If you have facts you want to testify to, then I'm going to place you under oath and you can explain to me your view of things. I'll take that into consideration. Then I'll let everyone sum up their position. Then I'm going to take a recess. Would you like to be heard? If the answer is yes, I'm going to have you take an oath or swear to tell the truth. Swear or affirm that what you'll do is tell the truth.
And you should also know, Your Honor, excuse me, that you would be subject to cross-examination.
Of course.
I don't need to put anything on the record at this time. I think I've gotten quite a bit on the record that this court has quite a bit to look at and before it wants to move forward. And I will say that I was tested by a medical doctor today. I was hypertensive. I was tachycardic. I am on muscle relaxers. I am having dizzy spells. And I do have an appointment with the medical facility for therapy for my neurological condition. So that needs to be on the record.
Okay, got it. And if I have you swear or affirm, if I have you confirm that what you just told me is made under penalty of perjury, you're willing to do that?
Absolutely.
All right, please raise your right hand. Do you swear or affirm that what you just told the court with respect to your medical condition is the truth, the whole truth, and nothing but the truth?
Yes, it is.
Thank you. You may put your hand down. Mr. Stege, you may summarize your view with respect at this point to the anonymous jury.
The case was made today for it. I think it's clear that from the testimony of Ms. Moreno that defendant Hillygus does not respect the authority of this court. He's made that clear at virtually every hearing in this case. Mr. Hillygus, although acting as his own counsel in this case, is not a lawyer, is not bound by the rules of ethics like Mr. Silverberg and myself are. There is great danger. In fact, there's discussion of plans to disrupt this case. I want to underscore this question of whether it's merely protected speech. Of course, it is not. Not all speech is protected speech. In this instance, 207-337, simulation of summons, complaint, or other legal documents. The crime he's charged with in this case, one of the crimes is these bogus or simulated legal documents. It's in the court record that they are coordinating to send these fake notices, bogus liens, etc. And so that really makes the case for an anonymous jury and the really targeted and expansive and harassing nature of these emails. Now, Mr. Silverberg's client, Mr. Handte, there was just testimony of this coordination between them. In my motion for the gag order, my second motion for the gag order on Mr. Hillygus, I attached emails showing Hante's coordination in that process. So to that extent, he is sort of tied into that. The court may consider as sort of an intermediate option that the information in unredacted form, to the extent that Handte is really, the court believes Handte is not sort of connected to this, although plenty of evidence to the contrary, that Mr. Silverberg alone have access to it if there's some distinction to be drawn between the two, that's Mr. Silverberg had access to it, but not his client, Mr. Handte. Overall, I think the better course is that it be anonymous across the board to all the parties here.
Thank you. Mr. Silverberg.
No, I don't think, Your Honor, thank you. I don't think any case has been made regarding Mr. Handte that would implicate the 5 factors that we've discussed that would support the granting of an anonymous jury. There's just nothing there with Mr. Handte. He talks a lot, and Your Honor has had discussions with him about that, and he has been sanctioned for that. And I think that is sufficient. I think Your Honor really needs to look at the effect this would have on Mr. Hante's presumption of innocence. Now, all of a sudden, if Your Honor thinks that Mr. Hillygus, that it should apply to him, I don't, but I'm not Mr. Hillygus' lawyer. But I don't think it should apply to him either. I don't think the factors are met. But they're certainly not met as to Mr. Handte. So he's left in Mr. Handte would be left in a very untenable position where he is having this anonymous jury wondering why is it anonymous? He must be some real bad actor. I just don't understand it.
But do you think that the evidence that walks in makes that connection, that there's something unusual? I guess maybe if they've had prior jury service.
Well, Your Honor, and I looked at that. I didn't just make that up. It's a concern that's raised by the courts. It's
Sure.
right there in the Shrya decision that I cited.
Well, we have to, in ordering an anonymous jury, after finding factors, would support the finding, the court has to take steps to minimize any adverse effect that it would have on the accused and their fundamental rights. And so,
I don't know how we get around that other than bifurcation. Frankly, if Your Honor thinks that there's been that strong of a case made as Mr. Hillygus, then the only course I think would be to bifurcate, because that case has not been made as Mr. Handte, and he should not be prejudiced on that basis. And I think the prejudice is real. That's why the courts are talking about it. They say, we are mindful of the effect this might have on the presumption of innocence. They're really concerned about it, and that's why it's such a high bar.
thank you. Mr. Hillygus, any final thoughts before the court takes a recess?
Yeah, I would like to object to Stege talking about simulated documents. I know that he doesn't have any training in the law because those documents cited all the authorities from the Nevada Revised Statutes to the Nevada Rules of Civil Procedure to case law from Supreme Court of the United States to many other authorities that I'm not able to pull up at this moment. But those documents were absolutely First Amendment rights. And they were actually filed in the court. Nobody was harmed by those documents. They aren't simulated by any means. It was an affidavit, there was a declaration, there was notices. They were absolutely not simulated. That was an assembly bill that wasn't even passed and signed by the governor until July. Some of the documents that they're claiming are simulated were created prior to that, so that's ex post facto. So they cannot go after documents that were created prior to the law. The legislature created some assembly bill, Assembly Bill 15, that talks about simulated documents. They're absolutely not simulated. They were legal documents. They're constitutional and have a First Amendment right for those. So I would object to him talking about what he doesn't understand the law, because he's not trained in the law. He's trained in statutes and codes, which are not law.
All right, court, thank you. The court will be in recess for approximately 15 minutes. We'll come back and move forward.
All rise. This court is again in session.
Thank you. Please be seated.
Mr. Hillygus, did you get a copy of the Nevada Rules of Criminal Practice? Deputy has it right there. All right. Mr. Hillygus, there's a copy for you that the court had printed out. You can take that back with you. I'm sorry you're having difficulty getting a copy for your review. The prosecutor believes, and the court understands it was available electronically, but now you have a printed copy for your use. This case will proceed with an anonymous jury. Here's why. The court does find that there is a strong reason to conclude that it is necessary to enable this jury to perform its fact-finding function and to ensure undue harassment, annoyance, or safety. First, let me talk about the reasonable safeguards that the court intends to utilize here to protect the accused, to protect all sides from any adverse inference. First, the town that the people live in will be not redacted. Their zip code will not be redacted. Their age will not be redacted. Whether they have ever been convicted of a felony will not be redacted. The nature of the work of any spouse, not redacted. Whether they have children, and if so, what ages, will not be redacted. Any notification as to their inability to serve, because, for example, they've indicated they have a medical issue, mental health issue, extreme inconvenience, undue hardship, travel plans, strong feelings, any other information that would ordinarily be identified on their handwritten or electronically filed questionnaires will remain. But their name, their street address, their social security number, their email address, any other identifying information will be redacted. The court intends to ask detailed questions of each of these prospective jurors to compensate in some way for the lack of specificity on the actual veneers. Also, this is equal on both sides here. It's redacted as to the defense and of course redacted as to the state. No one has a chance to go online and look these people up. No one has a chance to run criminal justice histories or be presented with a copy of criminal justice histories by the state from a database that it alone has access to. This court intends to often and regularly and often remind the jury as to the significance of the presumption of innocence at all stages of the case. There will be no discussion by the court or anyone else as to why this jury is being conducted anonymously. The state is ordered not to bring it up, the defense counsel and defendants are ordered not to bring it up, and their respective witnesses, of course, are to be instructed not to mention it. So the court finds these safeguards to be reasonable to make sure that an anonymous jury does not unduly infringe on the right of the defendants to have a fair and impartial jury. Now, what is the basis for the court's determination? Again, I've said this twice, I'll say it now a third time, there's no indication that this case has any organized crime impact or relationship, so that's a non-issue. It does not favor an anonymous jury. Defendant's participation in a group with capacity to harm jurors. And again, it's not, just physical harm, it's to harm them by harassing. And that's been established in the court's mind. There have been, through the course of the proceedings, not just today, but over the last year, several different concerns expressed in email form, in telephone form, and communications by those accused here with people that have the ability to cause chaos. The court incorporates the prior hearings, the prior email sent, the court record in both Mr. Hillygus and Mr. Hante's case. And it's not just Mr. Hillygus's actions alone. Mr. Handte has been used extreme rhetoric, both in person and hearings with the Washington County Commission, and also in his emails as recently as just last week. That's of concern to the court. Past attempts to interfere with judicial process or witnesses. I don't have any direct information. There's been efforts to interfere with witnesses, but the judicial process is not lost on the court that at least one email that's on file in this case suggests that a group of people are aware of where the Washington County District Attorney lives. That's not cool. That's concerning. Next factor, defendant's potential lengthy incarceration if convicted. Now, let's understand what that means here. At the time, the court conducted Ferretta canvasses of both Mr. Hillygus and Mr. Handte. We discussed the charges here and the potential maximum sentence, as I recall. As to Mr. Hillygus, he's facing 7 counts. The first 3 counts of being conspiracy to commit second-degree kidnapping, the second count being burglary, the third count, second-degree kidnapping of an older or vulnerable person. If Mr. Hillygus was convicted of all 3 of those, and if the court in its discretion decided to run the maximum sentences consecutively, that could be as much as 51 years. And then the additional, and that actually that's as to both defendants, 51 years for counts 1, 2, and 3. And then as to Mr. Hillygus alone, counts Roman numerals 4 through 7, prepare or delivery of simulated legal documents, that's potential 16. So as I discussed with Mr. Hillygus before he determined to represent himself, 67 years is the maximum sentence the court understands. 51 for Mr. Handte. Now, of course, that's just by law the maximum potential sentence. The court, quite obviously, suggests nothing by way of the strength of the evidence or by way of the sentence, if any, to be imposed. But a factor is the potential length of incarceration if convicted. So the potential is great. It's great. And then whether external publicity would enhance the possibility of the jurors being harassed. It would. It would. And I'm fully aware Mr. Hillygus, neither Mr. Hillygus nor Mr. Handte have been charged with any crimes associated with their conduct. And I'm well familiar with the First Amendment rights of people to speak their mind even on issues that might be unpopular to some other people. But there are limitations. Mr. Hante's violated that limitation once and served 3.5 weekends. I don't like the rhetoric that has been associated with this case. I don't like the very strong, potentially concerning language that's been utilized by people associated with these defendants. And the court will not subject the potential jury, men and women, to any type of harassment connected with their service. So for that reason, the court does order an anonymous jury. The jury commissioner's office is to redact consistent with this court's order. I see the jury commissioner herself here, and she'll follow the court's order. Wednesday, this court will get an unredacted copy and redacted copies, and hand out the redacted copies in open court. The objection to that has been noted both by Mr. Handte and Mr. Hillygus. The court did give some thought to an idea presented by Mr. Stege that perhaps counsel alone could, but that would unfairly prejudice Mr. Hillygus in the court's estimation. So the court opted not for that. That's the court's decision. Now let's slide over to our Nevada judges. They've asked for permission to be present and video and post the trial. Based on the hearing I had last week, I let all counsel and Mr. Hillygus know I was inclined to allow that unless something happened today that would change the court's mind. In addition, an open question was whether our Nevada judges would be allowed to post it daily, so people who are interested could follow along on a daily basis, or would be relegated to having to watch the entirety of the trial after it went forward. The court is inclined to allow it to be posted on a daily basis with directive to all counsel and to Mr. Hillygus to remind witnesses that the rule of exclusion is invoked. The court on its own initiative does invoke it, and they're not to discuss their testimony with other witnesses or watch the testimony from any days prior. That's the way the court's leaning on that issue. Before I order that, Mr. Stege, would you like to be heard? And then Mr. Silverberg and Mr. Hillygus. Mr. Stege.
No, thank you.
All right, Mr. Silverberg. Mr. Hillygus.
I just want to make a record. I object to preserve my appeal right of your decision for an anonymous jury. It's denying me a fair and impartial trial, and that's an appealable decision, and I just want that preserved for the record.
It's preserved. All right, then with respect to our Nevada judge's request to video during the trial, that request is granted. As to their request to post it on a daily basis, that too is granted. The court is convinced that they will follow the rules associated and proper with the court proceeding and act respectfully and professionally in the manner in which they conduct themselves. Mr. Hillygus, let me talk to you again. Now, would you like the court to appoint an attorney to represent your interest solely on the issue of medical concerns that you have that might impact your ability to move forward in this case? Because if the answer is no, no is no, off we go. If the answer is yes, I've got to do it quickly and see if I can get them here for Wednesday for a status hearing to see where things are.
I do not need an attorney because I have scheduled an appointment. I am under extreme medical distress. I have been, like I explained earlier, abandoned and left in the sun.
Let me stop you, because here's the thing
I'm
though.
on medication.
If you want me, as the presiding judge in this case, to do something with respect to your status, I need a request. I need a motion. I need a file motion with evidence, maybe a witness here, and we have a hearing, and then I make an informed decision. I heard what you said. You've testified under, penalty of perjury that it's true. But for me to take some action over the resistance of the state, I'm going to need you to file something, present something, be ready to go. Because right now we are go launch for trial 1 week from today. All right? Does everyone understand that? We are go launch unless in a review of what you filed last week, what you filed last week, unless that causes the court some pause or concern, putting aside its timeliness, but the substance, we are going to launch on Monday.
Those documents were provided to my public defenders, and they were asked to file those, and they failed to do that. They've also.
Well, you don't have a public defender.
Those documents were provided to the public defender and asked them to file, and they did not. So those were timely. They should have been timely. So they provided those to me finally, and those have been filed. But being locked down, being on medication, being unable to communicate, and even though you said I could communicate with my co-defendant, I'm being locked out of communicating with him. So I'm being denied my due process rights to prepare for trial because I'm not able to discuss anything with my co-defendant. So with my medical condition and appointments scheduled, been approved by injuries that sustained inside the Washoe County Jail, until I'm cleared from a medical physician to proceed, I am not prepared to move forward with trial, and it's a violation of my rights and my due process rights, because I'm being locked down and I'm not able to communicate with my co-defendant.
Well, I'm not postponing this trial based on that statement. Even if I'm not, right? We're a week out from trial. You do not have an attorney and you resisted the court appointing you one. You understand the limitations that apply to somebody's in custody. We've talked about your custody status and at previous hearings about how I take no pleasure in having you remain in the Washington County jail. None whatsoever. If there were reasonable ways to ensure that you would remain in this county, had a place to live that's been approved by the court, and had a reasonable bond and wore tracking anklet, you'd be out. But we haven't got there. So
My medical emergency only happened 6 days ago. So I'm under the care of a physician. I'm being isolated and I'm being in solitary confinement in the infirmary, and I'm being cared by nurses 3 times a day and medical doctors. So
well,
I would object to you not granting me time to recover from my medical injuries and the ability to be evaluated by a hospital here in Reno that's now approved. The county jail is gonna pay for it, and I've been scheduled for an appointment with medical physicians.
all right. Mr. Silverberg, any feelings you'd like to share about how you would have the court approach this underneath in light of the circumstances Mr. Hillygus has suggested?
Well, I think he's representing himself. He's made a motion to continue based on his medical condition.
Well, it sounds like he has, right?
Yeah.
This is an oral motion to postpone this trial to let him get on top of his medical
So
issues.
here's what I suggest, because he's in a very difficult position where he won't be able to have people here Wednesday, but Your Honor ordered somebody to be here today to talk about the anonymous jury, so I think Your Honor could order somebody from the jail to be here that can talk about Mr. Hillygus' medical. Maybe that's the way to do it, if that's what he wants to do, but Your Honor can certainly order that. And I think in light of the fact that Mr. Hillygus is representing himself, he has made that motion, and I know that the state and myself are anxious to know whether this is going to go forward or not. There seems to be, it seems to be quite unclear, but I know that we're both desirous of an answer sooner rather than later as we prepare for trial.
Well, it's not unclear in the court's mind. We're going to launch a week from today unless I have evidence to suggest that Mr. Hillygus is not well enough to proceed. So
I think the only way we have that is if Your Honor orders somebody from medical to be here for the hearing on Tuesday. Would that be somebody that I don't know any other way around it. I think it should be heard. I think it's a serious issue as to whether or not Mr. Hillygus is going to be prepared or whether he can prepare. And I'm concerned about whether his lack of ability to prepare is going to affect my representation, Mr. Hillygus.
okay, I understand your position. Mr. Stege, your thoughts, please.
I ask the court to slam the door shut today on this issue because many things are in the works for this, and a seed of a possible continuance is quite impalpable to the state. There are people here today. We have brought up this issue of the medical thing in our prior argument and prior testimony. Let's handle this today. Because it's not tenable for the parties to be working like this for then have it continue. That is just simply not tenable. So I propose a hearing be had right now on this issue. There's Mr. Hillygus can offer matters. There's people in the courtroom who can offer information on this issue, and the court can decide if it's continued or if it's not continued. Because
Well, I didn't have this scheduled for that. I'm not generally familiar with, I have a basic understanding of what the law is on whether somebody's medically able to proceed to trial, but I haven't reviewed the legal authorities on that lately. I could take, if there's somebody here today from the jail and Mr. Hillygus gives authorization, because if he doesn't, I don't have anything else to go on. But
well, if he doesn't, then there's no motion. We can't
so if
say I can say.
he gives authority for the court to hear, I guess I could hear the evidence today and then take it under submission and turn around an order within 24 to 48 hours on whether that's sufficient to allow this matter to be postponed or it goes forward. Or I set a hearing Wednesday and we all get geared up for that first thing.
A bitter taste in my mouth if we wait till Wednesday, only because.
Well, we're gonna be
there's so
back here
much-
anyway, we're gonna be back here marking exhibits, we're gonna be back here with the jury veneer, redacted, we're gonna be back here to go over the witness lists. So, I mean, it's not as though we're taking a day off, we're gonna be in court Wednesday anyway.
No, but dozens of people are setting up their lives to be able to prepare for testimony.
What if he had a stroke 6 days ago? What if he had a heart attack?
He did it. He was left out in the sun. He's overemphasizing it. He's planning to delay. The medical appointment we will hear is for a minor issue. The wheelchair thing has been a ruse for most of the time that he's doing this. So the court needs to hear that and shut the door on it today rather than leave it open for more delay tactics.
Mr. Silverberg, were you ready for
I
this?
suspect that's the evidence.
Were you prepared for that
I'm not
narrative?
ready for it, because I didn't know this was gonna be an issue today, other than I heard that Mr. Hillygus might be in the hospital, which I notified the court and state as soon as I had heard that. I think Mr. Hillygus should have the ability to have the person that could assist him the most in his argument about his medical condition. I don't know if that's the person that's here today. I don't know. But to the extent that he can speak for himself, that he should have the opportunity. I don't know that he anticipated that that person would be here today, or maybe this is the person. I'm prepared to go forward, but those are the concerns I have.
Okay, Mr. Hillygus, you heard the discussion I had with Mr. Stege. At some point, if you want me to postpone this trial because your medical condition doesn't allow you to go forward, I'm gonna need some evidence to base that decision on. Do you understand that? And it's gonna be more than your testimony. I'm gonna have to hear from a medical provider, a licensed medical provider, who can speak to that. Now, if that person is here today, I can at least take their testimony and then go research what the law is and decide what to do. If that person is not here today, I can order he or she to be here Wednesday, and I can see everybody at 9:30, we can take it up at that time, over the objection of the state, because they want to know today if we're going to trial or not. What do you think?
So I agree that the medical provider is not here today and that the medical provider does need to be here because that's the person that's evaluating me, that's reviewing my medications, that's reviewing and taking my vital signs, that's talking to me. And so the person that's here today is not the medical provider. And so I will not grant them the ability to speak because they have not been treating me. So the person that needs to treat me needs to be ordered to come here to discuss my care.
Are they an employee of Washoe County, or is it somebody coming in from the outside?
It's my understanding that they're a subcontractor for the Washoe County Sheriff's Department from NAFCare. And
Okay,
there's,
and if we have this hearing Wednesday morning, are you going to give your okay to allow them to speak to these issues?
if you order the two providers and the medical director, or not the medical director, but the two providers, I guess you could call them, they are licensed medical physicians, I believe. They're the ones that are prescribing the medications, they're the ones that are ordering my evaluation to be scheduled and approved at the hospital. Those are the people that need to be here, but the person that's here today is not
Not that
treating
person.
me.
Okay. Any final thoughts, Mr. Silverberg?
No, Your Honor, thank you.
Any final thoughts, Mr. Stege?
The idea it's a surprise is kind of, doesn't make sense because, of course, we heard last week about this issue. Before this court has that full-fledged hearing, right, he ought to be required to make a prima facie case.
Well, I put him under oath before.
Right, and so we know nothing about the medical condition, nothing about, and let's base this in the law, right? Always helpful to come back to the law, right, which is competency.
When in doubt, follow the law.
When in doubt, hey, let's go back to the law, right? And we're not making this on like an equities or like a feelings about Mr. Hillygus. We're basing this on with the law. Now, and so here's how I see it. If he's not competent, that would prevent a trial. We know that from a lot of case law and statutes. Outside of that, it's a discretionary call where the court believes there's good cause for a continuance. Now, I don't wish to come back to this, but the parties have a lot in motion on this, on setting this trial up, and for even 2 more days of that effort to go forward and the court continues it, I would wish not to waste that. Of course, I defer to the court's judgment on this, but let's, returning to the law, right? We have no idea what is at issue here. He wants to cause more, the idea that physicians should have to be here on Wednesday. I think that's much too high of an evidentiary standard given the lack of any prima facie case here, right? If it's competency, you would expect something like he's on PsychNet. I submit the answer to that is no, based on my understanding of the evidence. That he was left outside, and that is debatable. I think we could hear testimony today on the question, his sort of equity-based being left outside. But anyway, the effects of that quite minimal. And so it's not competence. I submit there's not going to be evidence. There's not evidence today. And if there's evidence to be had, let's try to get it today. Otherwise, it's simply a good cause continuance. Now, I'm happy to weigh in on that sort of analysis, but I think history ought to go into that assessment. So I'm against the continuance in the general principle, but I'm most against waiting 2 days and then having it continue. And thank you for your time, Judge.
All right, give me a moment. Mr. Stege, are you available 11 a.m. tomorrow morning for a hearing?
I'll be available anytime, Judge.
How about Mr. Silverberg?
I do have a docket tomorrow, but I should hopefully be done, part of it's here, so hopefully it'll be done by 11.
Okay. All right, it's the order of the court as follows. That the West County Sheriff's Office used best efforts to secure the attendance tomorrow morning at 11 a.m. for a hearing on Mr. Hillygus' medical condition from the person most knowledgeable about the care he's receiving. So the court can make an informed decision on whether this matter should be postponed. In the event the person's not available tomorrow at 11, then it'll be kicked over to Wednesday, 9:30. But we will try to have this hearing tomorrow at 11 o'clock. So again, the order is that the Washington County Sheriff's Office is directed to reach out to the medical provider that's providing care to Mr. Hillygus, and they have a representative here tomorrow at 11 o'clock to testify under oath with respect to his care or treatment, with respect to his ability to go forward with trial next Monday.
Your Honor, could we waive Mr. Handte's appearance for that hearing tomorrow?
Yes?
Thank you.
You're welcome. And then I'll make a decision. I'll make the decision after the hearing tomorrow. If that person is available. If for some reason they're unavailable, then I'll make a decision on the record Wednesday morning. That'll be our first up matter to take. If the matter goes forward, then we're going to go into the court passing out the jury open ears, marking of evidence, any other matter for the order. Mr. Hillygus, you have a question?
There were some typed grievances that were submitted to the Washoe County Sheriff's Department that I'd asked to be printed out and provided so that I could use those at the hearing tomorrow or Wednesday.
With respect to your medical care?
Yes, absolutely.
Are they within the last week?
Yes, they are.
About how many are there?
I believe there's 2 or 3 grievances that have been submitted, and I'd like those printed out so that I can use those at the hearing.
Well, that seems reasonable. I'll direct the sheriff to use best efforts to print out and have those available for the hearing tomorrow morning at 11 o'clock, or if the hearing doesn't go forward until Wednesday, then at 9:30. Now, here's the thing. Somebody needs to let us know whether 11 o'clock hearing is go or not. And so let's stay close to our emails to know whether we're going to have this hearing tomorrow or it's going to be Wednesday at 9:30.
Who would Your Honor like to hear from about that? I'm guessing a representative from the jail?
Yes?
Thank you.
All right. All right, anything else we need to go over at this time? Anything else from the state?
No.
Defense counsel?
I didn't mention about the notice of witnesses from the state, and the state's correct, it's 5 days, not 10. I operate off the 10, I don't know why, but it is 5. I do believe it's 5 judicial days, so I think Friday would have been the date. Point being, I'd like those meetings sooner rather than later, because it comes with.
Well, any reason they wouldn't be available today, Mr. Stege?
No,
All right,
I
please get-
directed they be filed.
All right, get them to both defendants here by the end of the day today.
And can we clarify whether Mr. Hillygus is on E-Flex after all, or?
My understanding is he's on E-Flex. So he's nodding yes, all right.
Thank you.
And then I'm directing Mr. Hillygus and Mr. Silverberg, you discuss who's gonna go second. You know, second to voir dire the jury, second to question witnesses. Who goes first for peremptory challenges? He's the A defendant, so he normally gets to go first. But if he wants to defer to you, being trained in the law, then I'll order that. But right now, he goes second. And I want to remind you, with these peremptory challenges, the defense side gets 4, the state gets 4. And so here's how it will go. When the court says, Mr. Stege, the state may exercise its first peremptory challenge, the state says we thank and excuse juror number 12 or 15, 3, whatever it is. Then I'm going to say the defense gets to exercise its first of 4 peremptory challenges. Mr. Hillygus, who do you want to exercise your peremptory challenge against? Assuming you don't waive it, I encourage you to exercise it. You say, Judge, we'd like to exercise peremptory challenge number whatever. And then I go back to the state. Then I go to Mr. Silverberg for the defense second. Then I go back to the state for third. Then I go back to Mr. Hillygus for your third. Then the state gets its 4th, and then you get to go your 4th. Then when it comes to alternate, each side gets 1. So the state goes first, and then the defense has to collaborate. Okay? You have to collaborate. But again, with the questioning of the witnesses and things like that, you need to, I want to know the order that you're going to want to do that.
I initiated that discussion with Mr. Hillygus, so he'll be thinking about that.
Okay, so I want to know by Wednesday, right? If we go forward after the hearing, I want to know. If we're not going forward after Wednesday based on medical concern, well, we'll know another time. Also, with respect to exhibit markings, the state numbers its exhibits 1 through whatever. The defense marks its, we'll start at number 100 and move forward from there. Okay? And that way, if the state has more to mark or the defense. All right. Do you need a moment to talk to Mr. Handte? No.
Can you include in that order that the sheriff's department open up my communication? They're blocking my communication with my co-defendant. I believe that you said that we now have permission to communicate, and they need to unblock.
Well, I'm not going to make a ruling on that. What I said before is the prior prohibition about communications when you were on pending warrant status no longer apply. So that's what I can say to that. If there's a concern that somehow you're being inappropriately treated, I'm not going to take it. I'm not going to build this airplane while we're flying it. I need a motion, and I need a basis, and I need the state to have an opportunity to be heard.
All you need to do is order them to unblock his number. I can't contact my co-defendant. They can unblock it right now. That's my right to communicate with my co-defendant regarding my strategy for the trial.
Well, I'm not making an order one way or the other on the manner in which the sheriff's office does its job. I've previously ordered them to have somebody here today, ordered them to use best efforts to clothe you appropriately. I've directed them to cooperate in getting your primary medical care provider here most knowledgeable about your condition for tomorrow 11, or failing that 9:30 the next day. And I've ordered them to use best efforts to print out the concerns, 2, 3 concerns you've raised over the last week that you'd like to use for that hearing. That's the limit of the court's order at this time. All right?
I'm also wanting to explain that there's multiple emails that I have sent that I would like provided to use for evidence from Missouri and from Washoe County that I have sent and people have sent to me. These are emails that I'm going to use for my evidence in this case. The prosecution is using emails from Missouri and phone calls from Missouri. I want to have the same opportunity to have the emails that I've sent from Missouri and the emails that I've sent from Washoe County that I can use as evidence.
So I don't want this to be like open mic. The state is aware of what its legal obligation is with respect to evidence in this case. Right now, I'm not prepared to address it any further. That will end this hearing. Thank you, everyone. I wish you a nice afternoon.
Thank you.
Recess.
All rise.